The Independent National Electoral Commission (INEC) recently called for a stakeholders meeting in Warri Federal Constituency in Delta State to commence a process geared towards giving effect to the Supreme Court judgment on the redelineation of political wards in Warri Federal Constituency comprising Warri North, Warri South and Warri Southwest local government areas. While the idea of stakeholders engagement in an attempt to enforce a court judgment by INEC looks commendable in the facial value of it, concerned Itsekiri leaders have described the move by INEC as a classic model of selective justice, gross disrespect for court judgment, marginalization, discrimination, and oppression. The leaders who were speaking during a press conference said the conference was necessitated by the bizarre, swift, and impulsive reaction of INEC to the 2022 Supreme Court judgment. Speaking on behalf of the concerned Itsekiri leaders, Chief Robinson Area said the said Supreme Court judgment only gave effect to Section 114 of the Constitution of the Federal Republic of Nigeria 1999 as amended with respect to minimum of 10 years provided for INEC to carry out political ward redelineation exercise as it relates to the current situation. He noted that while the law provided for a minimum of 10 years for such exercise to be carried out, INEC had, in contravention of the Constitution, illegally tampered with the political world in Warri Federal Constituency by converting the 10-ward structure of Warri South local government area to 12 wards, an exercise, as said, has been declared illegal by the appeal court, who had, in its judgment, ordered INEC to revert to the legal 10-ward structure, but wondered why INEC had not applied the same agility towards the Supreme Court judgment to enforce the appeal court judgment on the 10-ward structure in Warri South delivered over 20 years ago.
The proposed delimitation/review of Warri Federal Constituency comprising of Warri North, Warri South, and Warri Southwest local government areas of Delta State of Nigeria by the Independent National Electoral Commission (INEC). Whenever a review is required to be done, the principal tax drivers, that's the owner of the review, the people to perform the review, in this case INEC, must first ascertain and interact with the default position or the status quo. In other words, if you are asked to come and review the constitution of a club, you must know the constitution that was in existence. Otherwise, you cannot review. The concept of review presupposes the existence of something you want to review. Applied to the task before us, the status quo is very straightforward, simple, pedestrian, but has been made quite complicated by the Independent National Electoral Commission and some of the contending parties, stakeholders in this case, that are certainly contemptuous without any lawful justification. Perhaps this avenue will enable us to urge you as members of the fourth estate of the realm to engage INEC to provide justification for disrespecting a court judgment for more than 2 decades. By virtue of the applicable statute, Decree number 51, published in the Gazette of 1992, a copy of which we humbly attach herewith and mark annexure AR1. This is the Gazette. Up to today, this is the only instrument, the only legal instrument that talks about the structure, number, and nature of wards in Warri constituency, Warri South constituency 1 and 2. The AR1 stipulates the number and structure of wards that constitute the fair known as Warri South constituency 1 and 2. And it was, remained, and should remain 10 wards, namely Itsekiri, Ubeji, Obodo, Okere, Bowen, Kwesu, Avenue, Esisi, Ekurede, and Igudu wards. These are the only wards created by law. Every other ward structure amounts to gerrymandering. By the way, gerrymandering is a way that politicians divide political units to favor their interests. If you see, I'll give an example of what has happened. From what I've read out here, you can see that Ubeji was a ward, Obodo was a ward under the law. But they gerrymandered it to make Ubeji, Obodo, Egbokodo, Ifie, all one word. The law says Ubeji is one, Obodo is one. but the politicians came in. And yet, this issue should be a legal issue. It should be an issue of law. There is absolutely no law. I urge you, when you meet INEC, ask INEC, what is the law that establishes the structure of 12 wards with which they have elected people into the House of Assembly? That is the grounds. As you will see that the case we have in Warri is one that you cannot have anywhere in the world where there is rule of law. Read section 114 of the Constitution. It tells you that there are only 3 circumstances under which you can touch the structure, the shape, and number of wards. And that is 1, when it was done 10 years ago. In other words, every 10 years it is done. 2, when there is boundary adjustment. If Edo Delta shifts some boundaries, then you may need to touch ward structure. Then 3rd, when there is population census necessitating a revisiting of the structure and number. Now, let us remember the sum of every constitution, that any law that is inconsistent, that's section 1 subsection 3, any law that is inconsistent with the provision of the constitution shall, to the extent of its inconsistency, be null and void. So also any action of any government agency that is inconsistent with the provision of the constitution. I urge you to ask INEC whether any of the conditions contained in the constitution was met before the politically gerrymandered Warri South constituency. What the court said was that the gerrymandering exercise of INEC was null, void, unconstitutional, and of no effect whatsoever, which means they had to revert to the law, which was 10 ward structure. And distinguished ladies and gentlemen, members of the press, this happened 1997. Judgment was delivered 2003. Today is 2024, 21 years ago. A child born then, you know how old the child will be. How oppressive, how marginalizing can it be that a people who say they operate law, they obtained judgment 21 years ago, and we have been fighting, as you will see. There were several other orders and judgments trying to force INEC to ensure that this judgment was obeyed. What are we saying? We are saying that it should be 10 wards. INEC manufactured 12 and restructured it, upon which they are electing people. As we speak, there are members of the House of Assembly elected on the basis of this illegal ward structure, meaning that our taxpayers' money are being expended for illegality.
Chief Robinson Araya revealed that a legal committee process that was on the way to finally address INEC's flagrant disobedience to court judgment and others on the need to revert to the legal 10-ward structure altered as a result of an appeal by the current chairman of INEC, Professor Yakubu Mahmood, who promised they were going to implement the judgment, has now been revisited since, according to him, it has become clear INEC was playing a game of deceit and appears to be working hand in gloves with some individuals against the interests of the Itsekiri nation.
It is not possible to present a budget to the National Assembly when the entire country is ripe for resignation, for the National Assembly to approve such a budget. Questions to be asked. Why are you resignating in only 1 out of 770? What about my own? Because it's an exercise which Constitution says must be done after 10 years. And it's been more than 25 years since it was done anywhere in Nigeria, including Warri. The Supreme Court never nullified the structures that were on the ground. There was nowhere in the judgment where they nullified the structure that was on the ground before this judgment. And for which INEC has remained contemptuous for over 21 years. We have made the point that the issue in the Court of Appeal case is distinct from the issue in the Supreme Court case. But we are saying, assuming they are the same, that means some people need to go to jail. The reason why I say so is that the Court of Appeal case was a judgment decided way back in 2003. This new case was instituted in 2011. So if a lawyer or a litigant knows that an issue has already been decided, he doesn't file a fresh suit. If he has any grounds, he appeals against that suit. So if you file a new suit and you pull the wool across the eye of the court, not letting the court know that this issue has been rested, assuming you are arguing that the two issues are the same, then you are guilty of deceiving the court, because the issue had already been rested since 2003, and you are bringing your matter 2000. Their case was instituted, as you see here, on the 14th of April 2011. That is more than a lengthy time after. So they cannot claim it is the same. It is only if it is the same that they can talk about stare decisis. So the question, are the two issues the same? If Inec is saying they are the same, what it means is that an issue that has been decided by the Court of Appeal, you went back to the lower court to start that issue. Then somebody must be playing tricks on the legal system. Now, if you now say they are not the same, then you cannot talk about stare decisis. You can only talk about enforcing the judgments separately. What the Supreme Court judgment has said is, go and review. What the Court of Appeal judgment said is that the structure of 12 ward is illegal. Don't use it. And that's what Justice Bank said in 2022. Justice Bank then said that the appropriate thing to do is to jail those people who are responsible in the judgment I read to you just now. Those were his words. In this regard, therefore, we want the Inec to first dismantle the illegal structure it is currently operating with, in line with the decision that has just been made. To begin the process of executing the modernized structure, because as Londoni put it, Londoni is one of the greatest jurists that ever lived. In USA against McCoy, he said, and I quote, "You cannot do something or nothing and expect it to stand. It will collapse." End of quote. Like Inec did with isolating WARRI for review in 1996, leading to that court judgment. It has now set machineries in motion to isolate WARRI again for delimitation and review when the whole country is constitutionally due for it. Who passed the budget? Who submitted the proposal? Questions could have been asked. It may be that some external persons are responsible for financing this exercise.
Chief Brown Mene, the Ogwolu son of Warri Kingdom, who spoke in a similar vein, lamented the pain and deprivation the Itsekiri nation had suffered over the years as a result of countless illegalities being meted on them because of their peaceful disposition and resolve to always explore legal and civilized ways to fight for what truly belongs to them, despite their huge contribution as an ethnic nationality to the economy of the country.
If you come within Delta, what comes from the bowels of our land, that is the Warri Kingdom, is the highest. But if you go around our places, what you see is devastation. And because of our headcount minority, our hands are held behind our backs, so to speak, whilst we go on being plundered. But we can't go on watching without feeling how we are leading. And to find that in 1996, Inec singularly focused on Warri South local government and changed illegally, even within under 10 years, the 10 wards into 12 wards to disfavor us. Because the construction of it, we saw it, it was to disfavor us. And since then, we have been groaning, complaining, and asking for this to be rectified. Even till today, in the state legislative house, we are suffering because of that illegal limitation imposed upon us. We have not resorted to violence We have only resorted to means of addressing this in a civilized manner. And whilst we are reading under that, the Supreme Court judgment that did not single Warri Federal Constituency out for attention, for action, something that is applicable to the whole nation, Inec is coming again to zero in only on Warri Federal Constituency. And we are crying out loud, how much more should we endure? Are we no more part of this country? Should our laws be applicable to us? Should it be selective to our detriment from time to time? And if we cannot speak, who will speak for us? So that's why we are saying that even though we are taking the legal steps to address them, we have even made our voices known to the legislative arm of the government of this country, but we haven't had any listening here. Now we are resorting to still pursuing the legal means. But you, the fourth estate of the realm, please help us to cry out. Some of us are even asking, is there some invisible tail that is wagging Inec when it comes to Warri Kingdom?
Present at the conference include Chief Omar Eyewoma, the Ologbo Chair of Warri Kingdom, Chief Johnson Amachunlere, the Iya Chair of Warri Kingdom, Chief Gabriel Awala, the Uwangwe of Warri Kingdom, and Chief Anthony Unuwaje, the Old Shodi of Warri Kingdom, among others.